Good afternoon. We're going to get started with the webinar. Thanks for joining me today to discuss physician compensation. This is the most recent in our series of Holland & Hart Health Law webinars, and we're going to be talking for about an hour today. If you've dialed in, hopefully you can see my presentation and hear me. There's also a chat box, so if you aren't getting both sound and visual, feel free to let us know. I'm Kelly McIntosh, and I'm an attorney in the Reno office of Holland & Hart. Today we're going to be discussing physician compensation. We're going to discuss some of the laws and liability that relate to how compensation arrangements can be structured, give you some examples of different compensation arrangements and the risks of structuring compensation arrangements incorrectly, including some horror stories and recent enforcement actions. Going to discuss both some of the traditional compensation models and how some of those models are changing with healthcare reform and some of the new ways that compensation and value are being looked at in the healthcare sector. We're going to discuss some contract terms to consider when setting up compensation arrangements with physicians, and also touch on additional considerations that 501c3 entities have in regards to compensation. Just a couple things to get out of the way before we get into the program. This webinar, along with all of our health law webinars, are recorded and available for download or to pull up and listen on our health law blog. We also have other healthcare resources there, client alerts and other things that we have sent out and put together. We also post on our blog. I hope all of you received the written materials for today. That should have included the PowerPoint slides, a handout that I find pretty helpful as a pretty bare bones but good comparison of where the Stark Law and anti-kickback statutes are similar, different, and where those either or both may come into play with your relationship. It's a one-page handout which is handy to pull up when you hear those terms. Oh, sorry. And finally, there was a CMS chart that was actually in the Federal Register some years ago, which compares some of the Stark exceptions and lets you know some of their differences. Again, just kind of a handy resource to pull out when you're looking at some of your arrangements. If you have any programs during the program, any problems during the program, please feel free to either, as I said, mention something in the chat box, or you can also email Luke Kelly. And as well, if you have any questions while we're in the program, feel free to put them in the chat box. We are just going to have the hour, so I'll try and get to questions at the end if there's time permitting. If not, also feel free to email me, and I can respond to you offline with questions and things that we might have touched on. And some of the disclaimers just need to throw out there also before we get started. This program is just going to be a general overview of legal issues and considerations regarding physician compensation. And I'm an attorney. I'm not a business consultant or valuation consultant, so many of these things will have separate issues on the business and valuation fronts. I'll touch on where some of those issues and considerations probably are at least warranted, but I'm going to be focusing on the legal constructs here. This program does not establish an attorney-client relationship, and it does not constitute the giving of legal advice. So with that said, let's get underway. Some of the laws we're going to go through and talk about are the anti-kickback statute, the Stark Law, which is the ethics and patient referrals law, the civil monetary penalties law, the False Claims Act, whistleblower and qui tam actions, which relate to those federal laws typically, and also, as we'll discuss some of the state law counterparts and not necessarily get into specifics of any one state law, but I'll also kind of let you know where you may want to consider and look to your specific state's laws and counterparts on some of these items. And with that, fee splitting is something that will come in for most professionals in how compensation arrangements can be structured. The anti-kickback statute is a federal statute, and it's a criminal statute that provides that you cannot knowingly and willingly offer, pay, solicit, or receive remuneration to induce referrals for items or services covered by federal health care programs. Federal health care programs is more broad than just Medicare and Medicaid. It includes TRICARE and largely any health care program that is funded with federal funds. And the only way that you can not violate the statute if you are paying or offering remuneration for referrals is if an exception or safe harbor applies, and that would protect your arrangement. The one thing I would note with the safe harbor and exceptions to the anti-kickback statute is that if you're looking to rely on an exception or safe harbor, you must meet the components of the safe harbor completely. Because this is a criminal statute, there is an intent component, so it's not a strict liability statute. There must be the intent to be paying or receiving remuneration. However, as the next slide will show, that can be very broad in what can be seen as intent and remuneration. The penalties for violating the anti-kickback statute can include, because it's a criminal statute, up to 5 years in prison plus $25,000 if you're found in violation for individuals. Additionally, there can be $50,000 penalties per violation plus treble damages. Both organizations and individuals risk being excluded from Medicare and Medicaid for violation of the anti-kickback statute. And if there's remuneration paid in violation of the statute, repayment of any monies paid in violation would also or could also be required. As I mentioned, the intent is required here. However, under the statute, only one purpose of the remuneration needs to be to induce referrals. So even if there are other legitimate business purposes and the arrangement in most respects looks to not be trying to induce referrals, if even one purpose is to induce referrals, that's enough for the government to hinge on and seek prosecution under the anti-kickback statute. Additionally, definitely want to remain mindful of how broadly remuneration has been construed. The OIG has issued some fraud alerts that have given good examples for this. Some of the things that jumped out at me as things that wouldn't always be considered remuneration because they weren't always the exchange of money were these examples here, and especially the second, offering free training for CPT coding or laboratory techniques in and of itself could be remuneration if it's, and then could implicate the statute if the purpose is to induce referrals. The OIG does have good guidance if you want to look both to their fraud alerts and some of their compliance guidance documents as to what has been seen to fall within the constructs of remuneration. This is a little, and I have a similar one of these for the Stark law comparison, but this is intended to show you how the anti-kickback statute works to both sides of a relationship. Both parties to an arrangement that is in violation of the statute can be held liable. So you could have a facility physician, vendor, consultant, patient, anyone who is receiving remuneration on or paying remuneration on either side of a transaction, and referrals for patients are then going between the parties is enough to implicate this statute. The Stark Law is the next federal statute that we'll be talking about, and this is a little bit more restricted in its scope. It's a civil statute, and unlike the anti-kickback statute, it's strict liability. So you have to meet an exception to the Stark Law, or you would be found in violation. And the way you would be found to violate the Stark Law is if a physician, as that term is used, or their immediate family member has a financial relationship with an entity, then the physician cannot refer designated health services, usually just referred to as DHS, to the entity, and that entity cannot bill for such services. Under the Stark Law, the definition of physician is both MD and DO physicians, dentists, podiatrists, optometrists, and chiropractors. So it's a specific usage of the word physician in the parameters of the Stark Law. Additionally, designated health services are a distinct set of services. They include general categories like therapy services, which includes physical, occupational, speech therapy, lab services, imaging services, durable medical equipment, and prosthetics, all inpatient and outpatient hospital services, and among other categories. And there's actually also each year a list of designated CPT codes that are considered DHS published. And if you have any doubt whether or not your arrangement is going to be brought within the Stark Law, or you're talking about referrals to DHS, I encourage you to look to the updated list of CPT codes, because sometimes I'll go back to that list time and time again, and I'm often surprised where things that either seem to be similar to codes that are DHS happen not to be, or vice versa, codes you may not expect and services you might not think fall within DHS actually are on the list. So just keep in mind that you may want to check and determine if you're dealing with DHS. The penalties, if you are found to violate the Stark Law, include up to, payment penalties up to $15,000 per service or $100,000 per scheme of impermissible referrals. Again, repayments of the denied or of the improper referral services, denial of your payments, and as well violations of this statute could be looked at in consideration of exclusion. Similar to the anti-kickback visual I had earlier, here's the Stark Law visual, and it's a little bit different in that the way that the Stark Law and arrangements would flow is that there's a financial relationship between a physician or an immediate family member, and then the physician or family member makes a referral to the DHS entity, which is the entity that submits the claims for the DHS services. So it doesn't quite flow exactly the same as the anti-kickback statute. Often relationships will implicate both, but sometimes they won't. So it's often again, that OIG handout is helpful to look to make sure that you're dealing with both statutes or one statute or not. And another thing to mention with the Stark Law is that it applies to Medicare and Medicaid. It doesn't have quite as broad a definition as the anti-kickback statute, which goes to all federal health care programs. The next law is the Civil Monetary Penalties Law. It prohibits certain conduct, and the things here I wanted to touch on is first providing inducements for limiting services. So if, for example, a facility had an arrangement where there was some inducement provided to providers to limit the services that were provided to federal program beneficiaries, then both the provider and the facility could be found liable under the Civil Monetary Penalties Law, and penalties could be up to $2,000 per patient in that case. The other issue, especially in regard to setting up physician compensation relationships, is that this law prohibits contracting with excluded persons. So when you're setting up any relationships with physicians or providers or anyone as a healthcare provider, you want to make sure that you're not dealing with someone that's been excluded from the federal healthcare programs. And violation of this law in and of itself can also lead to exclusion. And if you were found, for example, to be contracting with an excluded person, you could be facing penalties of up to $10,000 per claim. There was actually just a recent proposed rule the OIG promulgated on this law as well that I wanted to highlight. It was proposed earlier this month, and it is promulgated under the Affordable Care Act. And pursuant to that rule, if you are aware that you have made a payment in violation of this law and you don't return that payment within 60 days, the proposed rule would have enhanced penalties of $10,000 per day for each day beyond that the prohibited payments are not returned. So that rule has yet to be finalized, but it is out there and could substantially increase the penalties, especially once a party becomes aware that they've received a payment or made a payment in violation of this law. And final federal law I'm touching on before we get into some of the other items is the False Claims Act. And this law actually relates to the other three laws substantially because often this is actually the law that the government will bring in to recoup the monies under the other laws. For instance, as noted here, the violations of the anti-kickback statute are automatic violations of the False Claims Act, and that's because this law prohibits submitting a false claim for payments to government entities, and if you're in violation of those other laws, they're considered false payments. So the False Claims Act requires triple damages. It's a statutory requirement plus between $5,000 and $10,000 per penalty. So when the False Claims Act is brought into the mix, that's where penalties go up substantially because of the triple damages. And this is also leads into the next section I'm going to touch on, which is key TAM actions, and that's where a large amount of the cases these days in fraud and abuse are coming forth. Without getting into all the specifics of a key TAM action in general, just wanted to let you know that this is whistleblower cases where typically a relator files a case under seal, and then the government, along the lines of the case proceeding, determines if it wants to intervene. The seal is at least for 60 days, but sometimes cases can be under seal for months or years. So if you're if a facility or an organization is under investigation, they may not even know that there's a case out there for a substantial period of time. And one thing to note is that relators are often former employees, competitors, or others with inside information. So as you're putting together your arrangements and relationships, make sure that you realize that anyone with information or competitors that hear what might be happening in your organization have a substantial incentive to report with these cases, and they're a primary cause of, or a primary source of where these cases come about. And the government is definitely pursuing a lot of these cases now. Absolutely, they're increasing in amount and leading to especially other, the key TAM cases will often lead to other investigations as well, because once something is pointed out as an issue, often the government will look more closely at billings of other types of services or compensation arrangements with other types of providers. So they also can lead to many further consequences for an entity. And I did want to mention that state laws can come into play. Most states, or many states, I would say, have either mini Stark and anti-kickback statutes. So that would be a state law comparable that would prohibit referrals and how referrals to entities that have financial arrangements or there's compensation for referrals can occur. They're not necessarily tied to source of payment. So the federal laws are tied to some source of federal reimbursement. The state laws are not necessarily that restrictive. In Nevada, for example, our state mini Stark doesn't have any source of payment. So it could be from a federal or state payer, it could be from a commercial payer, it could be cash pay. There's no limitation in the statute on the source of payment. Many professional licensing statutes also prohibit fee splitting, which would be paying or splitting fees for services not rendered by the professional. Often that's considered unprofessional conduct and could be a reason that a professional is sanctioned or investigated by their licensing board. And also some states have limitations on how different providers may work together. Again, using an example from Nevada, there's, for example, a specific prohibition, or not prohibition, and also limitation on how optometrists and ophthalmologists can share fees in the context of cataract follow-up care. So it's kind of unique limitation, but there's definitely, you want to be mindful that your state may have specific limitations on how payment and compensation between providers can work under state law. And again, typically, some of those penalties, some of the state laws will have fixed financial penalties. Often they also will be things that can affect licensure and be tied to revocation, suspensions, or at least limitations of licensure, or at least investigations of licensure. Did want to give you a couple horror stories before we jumped into how you can avoid getting into these situations. 2012 was a record year for the OIG in recovering funds for fraud and abuse actions. They had over $6.9 billion in recovery, and you can see over 3,000 exclusions, many criminal and civil actions. In 2014 so far, I just had checked this yesterday, and there are over 30 new corporate integrity agreements, and we're not even halfway through the year. Corporate integrity agreements are typically entered into in connection with a settlement with the government where there's allegations of violation of, for example, the Anti-Kickback Statute or False Claims Act, and a settlement amount is reached, and as part of the settlement, the government will require the entity to agree to have review of their claims often, usually to make certain compliance adjustments in how they do internal compliance, and they can last for many years. Most seem to last at least 5 or so years, so they can really impact an organization for a period of time, both because you have the government checking in on you and, you know, auditing or requiring audits of claims and things like that more so, and as well as the financial cost of engaging in some of the actions that are required by the CIAs. And these two actions I had just pulled up, they both came out just yesterday in press releases. So these are very, very recent, but these were both two recent DOJ, Department of Justice, and Office of the Inspector General settlements. Both of these had corporate integrity agreements attached to them. Medtronic had a $9.9 million settlement, and it was related to allegations of kickbacks to physicians to promote use of their devices. The one that was bigger and also interesting to me because it resolved both kickback and Stark allegations was for King's Daughters Medical Center, and it was a $40.9 million settlement, which was related to both allegations of kickbacks and prohibited financial relationships, and it also resolved allegations of Stark violations, and specifically the allegations on the Stark front were that the hospital was allegedly paying cardiologists unreasonably high salaries, which were above fair market value. So and the corporate integrity agreement that the hospital entered into was a 5-year review of all of its federal program claims, as well as making substantial compliance adjustments in its compliance programs. And one big thing that goes beyond just the dollar amounts and what's required is in having an issue like this come about, the reputational risk that organizations face as well when an organization has been subject to press releases and, you know, made sort of an example to the healthcare industry. Obviously that doesn't necessarily look great in a community, especially if it's a smaller community. So beyond the financial and maybe quantifiable risks, there's definitely also reputational risk for having even allegations of violations come about in a federal investigation. And just for comparison, those last two examples were from DOJ and OIG settlements and related to anti-kickback, though the hospital one also talked about Stark. There is a self-referral disclosure protocol now for if an entity becomes aware that they've referred in violation of Stark. And those settlements, I just think it's interesting that when you compare the amounts for entities or groups that have made self-disclosures, the settlement amounts are often substantially less. So I would hope, and it seems like that's probably that the government is wanting, you know, people to bring forth information they have and make it a less painful process if an entity kind of says, oops, and here's what we found, we're willing to work with you to make the repayment. So just as a comparison, the amounts here are substantially less than the many million-dollar settlements that otherwise can come about. So getting to how you can structure your compensation arrangements to not run afoul of the Stark anti-kickback statutes. With physician compensation, definitely, again, keep in mind on the federal level, if you're looking at federal health care program reimbursement, that's the only instance where the federal statutes are going to come into play. But again, your state laws may bring in other payment sources. A few of the potential exceptions that we're going to touch on are the bona fide employment relationships exception, which goes to both the Stark anti-kickback statute, personal service arrangements, which goes to both, the physician services exception, which is specific to Stark, also the fair market value exception, which is specific to Stark, and investment interest in a group practice, which is an anti-kickback safe harbor. And one thing to note on the state law front, this again is specific state to state, but where you do have a mini Stark or mini anti-kickback statute, sometimes there are comparable exceptions, sometimes there aren't. Some state laws really don't have any clear-cut exceptions, so it's worth also, if your state does have a mini Stark or mini anti-kickback, also trying to see how that has been enforced and implemented by your state authorities. Sometimes relying on one of the federal exceptions will still go far to establish to your state authorities that you're not engaging in something that is going to affect or hurt the quality of care or resources in the healthcare system. And that's often because it would be tied to things like fair market value and commercially reasonable terms and some of the things we're going to talk about in these federal exceptions. Going to the first, this is regarding most of the exceptions to safe harbors, and you'll notice as we're talking throughout that some of the key elements are always going to circle back to fair market value. Anything that is not fair market value will put forth the question of why. Why is it either below or above fair market value? And often, or at least there's often a potential that the reason is because of the patient referral relationship that's going on there. So setting things at fair market value doesn't leave any doubt that it's the fair market value for services rendered. We'll get into what fair market value means in a few slides and how that's not necessarily a single number or something that you can point to readily, but it's a concept used throughout these safe harbors and exceptions. Also, commercially reasonable and commercial reasonableness is similarly something that's a key element, and if you don't have that, again, leads to the question of why is this arrangement not commercially reasonable? And another key factor is that the arrangement and compensation is not determined based on the volume or value of referrals or other business generated between the parties. One other thing just to highlight, beyond some of the specific state statutes you might have on provider relationships, certain states also have limitations on how your arrangements can be structured. For example, there's a decent amount of states that are corporate practice of medicine states that have different prohibitions on what type of entities can employ physicians directly. Some states have specific, while they may prohibit a non-licensed or non-provider, purely unlicensed person or from employing a physician, may have exceptions for hospitals to employ or certain parameters on where non-physicians or non-providers can employ other physicians. So you'll want to keep mindful of those as well, because some of these safe harbors and exceptions may or may not be applicable or be possible to use if they won't otherwise fit in how you need to structure your relationships. For the employment exception to the Stark Law and safe harbor to the anti-kickback statute, the key elements include that you have a bona fide employment arrangement, and that bona fide employment term goes back to the IRS test on when someone is a bona fide employee. So Among some of the things that are included in if you have a bona fide employment relationship include if there's behavioral control and financial control in the, by the employer of the employee, and also other specified relationship factors. But it is tied to the IRS determination of that. The compensation under an employment arrangement must be fair market value and not determined in a way that is based on the volume or value of referrals. However, you can have productivity, which would be looked at, obviously direct services provided for personally performed services in an employment arrangement. Employment arrangements are not required to be in writing. That's not one of the factors it is for many of the other examples we're going to, or safe harbors and exceptions we're going to talk about. Often employment arrangements are in writing, and to make sure that you're documenting that you have compensation with fair market value and not determined in a way that is based on volume or value of referrals, often that's helpful to do through a written arrangement, but it is not one of the factors required to meet the exception in safe harbor. And it, as you'll see, as we can go on to the independent contractor potential exceptions and safe harbors, you'll see that the employment constructs are more flexible. So often, if that's an option or something that parties are open to, it will give more flexibility and ability to change or, consider different factors in their arrangement than the other exceptions will. And you'll see that's the case as we go into the independent contractor exceptions. This is the personal services exception, and it requires a written agreement. So for written agreements, or for independent contractors, you have to have a written agreement. You have to have a term of at least 1 year. Again, comparing that to the employment, you don't have to have a term. There's no set time period. Here you have to have a term of at least 1 year, and with regard to the Stark exception, if an agreement is terminated short of 1 year, you can't enter into another arrangement covering the same services within that 1 year term. So it doesn't mean that someone has to be forced to provide services for the full year, obviously, but if it terminates even at, after a month, the parties wouldn't be able to enter into another arrangement covering the same items or services until the full 12 months since the first agreement was signed has run. To utilize this safe harbor under the anti-kickback statute, if you're talking about provision of services that are less than full-time, you need to provide an exact schedule of when the services are provided and how much compensation is tied to those exact units of services. And again, just keep in mind that if you're needing to comply with an anti-kickback safe harbor, you need to meet the terms of the safe harbor to the full degree. So, for example, if you had a part-time physician that you were looking to contract with and you utilize this safe harbor, you would want to specify that the physician would be providing services Monday and Wednesday from 1 to 4 and receive X amount of compensation for those 3-hour blocks of time, or something along those lines, so that there is the exact schedule of services. Again, as with the employee exception in safe harbor, compensation for the personal services exception in safe harbor needs to be fair market value. It needs to be set in advance, and the anti-kickback statute specifies that the aggregate compensation needs to be set in advance. And usually, the set in advance means that it can't vary over the term of the arrangement. If you set forth a formula with specificity in the agreement as to how the compensation will be determined, that's been found to be set in advance sufficiently, but it can't be something that changes month to month, or that the compensation formula or the method of determining compensation changes within the term of the agreement. And also, again, not based on volume or values of referrals. So as you'll see, there's more flexibility with employees than independent contractors, given some of these constraints. The fair market value exception, which is an exception to the Stark law, so it would not be something, if you were needing to meet an anti-kickback safe harbor, this would not be one you would look to. But for the Stark law, This exception requires a written agreement. It can be for any specified time, but you can only have one arrangement in a one-year period. So you could have a 6-month agreement that you were utilizing this exception for, but you couldn't have a 6-month agreement that ends and then you enter into another 6-month agreement or a 3-month agreement or something within that one-year time period. For this exception, going to its name, you need to have fair market value compensation. This also needs to be set in advance and again, not based in a way that considers volume or value referrals. There are also some other exceptions, primarily the physician services exception, but there are some other exceptions that look to when you're dealing with a group practice, as that term is used in the Stark Law. And you need to keep in mind that if you're utilizing one of these exceptions, you need to, as a primary concern, have a group practice. That is defined to have certain factors in the Stark Law, but it largely goes to the concept of not having a loosely affiliated group of physicians, but rather an integrated group practice that is providing substantially all of their services through the group, billing as a group, has members or employees as a large component of the group. So it's not an easy concept or an easy determination to make if you have a group that is really just trying to come together loosely and not kind of share and act as a group practice in total. If you do have a group practice, however, this exception would require that again, you have fair market value, not determined based on volume or value referrals, compensation set in advance. But utilizing this exception, you can pay for overall shares of the designated health service profits so long as, to all the group members, so long as those are not determined based on the referrals of DHS by any group member. This works both for personally performed services and services that are performed incident to physician services, but doesn't go to ancillary services that may be billed by the group. And there is what's sometimes referred to as the 5 or more rule, which if you have a group practice, you also may be able to split DHS pools into groups of 5 physicians or more and share in DHS profits based on those groups. So depending on the size of your group and the services provided, that also gives some flexibility as well on how profits can be shared. And that's why often the group practice exceptions are things that groups of physicians would like to meet, because the other exceptions we talked about previously, the independent contractor exceptions, doesn't allow for getting a split of the group profits in and of itself. That's where you need to look to the group practice exceptions. So fair market value, that's the term that keeps coming up here. And I'm going to note right now we're talking about fair market value in the constructs of the Stark Law and anti-kickback statute. When we get a little bit later in the program to touching on 501c3 entities, there's a different fair market value definition and way that term is used within the IRS and nonprofit entity context. So fair market value for what we're talking about now in dealing with these exceptions, excuse me, to the Stark Law and anti-kickback statute means that the compensation would be fair market value if we were talking about parties who are not otherwise in a position to generate business for each other. So if you took out the concept of sending business back and forth and just had that these informed parties were bargaining to establish their arrangement, if the compensation would still be adequate and appropriate, that's the threshold for determining if it's fair market value. There's definitely a lot that goes into this, however, beyond just that term. Commercial reasonableness is a central part of this, and there's often things that are commercially reasonable in one setting that might not be in another setting. For example, a community may have a significant need for a specialist to get a specialist provider there, they need to pay a bit more. That could still be commercially reasonable and within the range of fair market value. But I would highlight again and again on both fair market value and commercial reasonableness to make sure that you document why you've come to the conclusion that this is within fair market value and that this is commercially reasonable, especially where you have circumstances that you're needing to pay someone more than you would in a perfect world where you had a great array of providers ready and willing to come work with your organization. There are surveys that are published. There's many different commercial companies that publish surveys on fair market value for different specialties, different services, different locations. There you can find surveys that look at physician compensation in a variety of ways. If you're looking to surveys, those are, I think a good starting point, and you'll again want to document if you've looked at a survey to reach your compensation. When you're looking at surveys, though, as a rule of thumb, you probably would be well served to at least consider being within the 50 to 75% range, or using that as kind of a starting point of where you're going to have your compensation, because if you're on the 90 plus percentile, again, that's going to be more likely to be cases where there might be certain service or circumstances that required, the commercial reasonableness required paying a bit more, or had other factors that went into it. So if you have those factors, again, just make sure that you document them. So if ever questioned, you can point back to why that's okay. Fair market value, sometimes you really can look at it either objectively or subjectively, and that would be, based on some of the national data or your specific, even community data versus your specific circumstance with a certain physician. Unfortunately, courts are split as to which way is the correct way to look at it. So again, I think documenting why you're picking the compensation you are and the thought process that went into it at least will help your position if you're challenged a year, 2 years, 10 years down the line, and especially when people that may have been the decision makers at that time may no longer be with the organization. Did want to just give you a couple horror stories with fair market value. And some of these cases you may have heard the names in the news. The Toomey case was a very big news-making item. It was a case that was involving relationships with the hospital system, and where part-time physicians were hired for 10-year terms. The agreements included non-competes that lasted for that whole time period, and they also required procedures to be done at the hospital or affiliates. The issues involved in the case included fair market value for the compensation, having compensation tied to volume or value of referrals, and other allegations. The case initially came down with a $45 million verdict against the hospital. The government actually challenged that, and upon it being reheard, the Toomey was found to be liable for $237 million. That's on appeal, so to the Fourth Circuit. So we'll see where that comes out. But as it stands, they have a $237 million verdict against the healthcare system. And of note, this actually, I've just seen a news item this month, even setting aside the current verdict against the system, Toomey's already paid $18 million in legal fees so far. And obviously that's something that is going to be an outlay really no matter what the end result. So even beyond the specific liability for violations that may be found to be against them, they also had a significant amount of legal fees, and I'm sure that will continue as their appeal proceeds. The other case was the Halifax healthcare system case, and in that case, this was actually a whistleblower case brought forth by a compliance officer. So again, folks that are in the know for your organization, or obviously are people that are aware of how your compensation arrangements are structured, often will turn into whistleblowers who can start a case against you. That case also involves fair market value, commercial reasonableness, and the volume or value of referrals. And I'm sorry, in that case, there was a settlement for $85 million. So again, large ticket item against the facility. Going into some of the compensation models, some of the traditional compensation models that have been used more so have included a straight salary, and often the current trends based on recent survey data I've seen is that still currently most compensation with physicians is not value-based purely. It usually will have some component of incentive compensation. About 85% of physician compensation arrangements currently have some incentive component. However, the mix currently is that about 80 to 85% of compensation would be based on a straight base compensation amount, and then 15 to 20% of the total compensation would be based on some incentive component. Historically, the compensation component or the incentive components that have been utilized were tied to things like productivity, which would be based on relative value units, collections, net income, or sometimes patient visits, number of patient visits. And some of the non-productivity incentive components historically have been quality and patient satisfaction. And under healthcare reform, the non-productivity-based incentive components are on the rise, and I think will continue to increase. Quality and patient satisfaction are things that are being looked at more to try and make sure that the quality of care that's provided is going to be, both helpful to the patients and also something that minimizes the cost to the healthcare system as a whole, because it's of quality that doesn't require as much care than after the case. The Affordable Care Act has increased the focus of the efficiency and shared savings components of some of the non-production or pure service-based compensation. And it's sort of an interesting state that we're in right now, because some of the goals of making efficient care and having some shared savings models raise other concerns in the context of the Stark-Nanny kickback world. For example, if you'll have a shared savings component that looks after care is provided back to all the providers involved, and if the care met certain thresholds of amount and duration, et cetera, it's hard to then set compensation in advance, because that would be looking back after the fact. There hasn't necessarily been clear-cut lines in all settings as to where that may or may not run afoul of the Stark-Nanny kickback statutes. There is a waiver for Affordable Care Organizations, ACOs. However, that waiver for Stark purposes is only for the Medicare shared savings participants. So if you're in a Medicare shared savings program, that would apply to you. However, for commercial ACOs or other non-Medicare shared savings structures, the ACO waiver is not applicable. So it's something that I think is going to continue to develop, and is, unfortunately, there are investigations and determinations that people have done things either right or wrong. It'll begin to become more clear as to where those lines lie. But I would definitely keep in mind that again, this is a place to document why you're setting your compensation using your quality-based conditions or efficiency and shared savings conditions. If you have metrics that you're looking at, that's definitely recommended, and having specific metrics that you can tie your compensation back to is helpful, but you'll want to make sure that those are up to date and revisited frequently. And some of the concerns that you'll want to watch out for and document why your compensation would not be promoting these activities would be with efficiency and shared savings, for example, that could lead to cherry picking of patients or steering patients to be discharged in ways that won't affect the group that is sharing in the savings or looking at the efficiency of the care overall. So while the goals are good to make care more efficient and have coordination of care across specialties and post-discharge from facilities, there definitely are concerns that it could have other effects of people trying to kind of game the system. So anything you can do to, as you're setting up your compensation arrangements, again, to document why your arrangements aren't doing that will be very helpful. Just now I'm going to cover some of the suggested terms for your arrangements with physicians. Obviously, in any agreement, you're going to want to specify the different types of services that are covered. That'll include the schedule, locations. If you're the organization contracting with the physician, you'll often want to, especially on the location front, reserve the right to modify that and add or remove or change locations or the schedule. Again, on the schedule piece, if you're dealing with some of the part-time situation, you're looking to the anti-kickback safe harbor, you'll need to specify the schedule up front with specificity. Be helpful, you want to include the right to bill and collect for your services and to contract with payers on behalf of the physician. Be mindful of how you address moonlighting or outside services in arrangements. You'll want to touch on things like if compensation from those services goes to the organization or to the physician, and beware of how malpractice coverage may or may not apply to those services. If they're still done, if they're outside services still done on behalf of the organization, malpractice may cover. You'll want to check the policy, but oftentimes malpractice coverage will not extend to things outside of the organization you're dealing with. So both the physician and organization should be aware of that up front. Including performance standards, especially things like the record-keeping requirements and that the physician needs to comply with applicable laws and the governing documents and policies of the facility is something you'll want to do, because if you need to point back to a violation and why that is a breach of the agreement, you need to have that term in there. Compensation, again, looking to how you're initially going to start the compensation. If there's a base amount, that's very important. If there's specified service compensation, and what I mean by that term is things like if there's a set amount for serving the medical director or per call shift or certain separate components of compensation, also set that forth and describe the bonus incentive compensation. With bonus compensation, it's important to touch on when the bonus would be paid and earned, and things, for example, like if the agreement terminates during a incentive or bonus period, does the bonus get paid out at that time? Is it only earned and paid on the conclusion of a full period? So if the agreement terminates short of that, there's no bonus earned or paid. Resolving those things in the agreement up front avoids ambiguity and dispute later on. Additionally, other types of bonuses that you might have, like signing bonuses, loan repayment bonuses, relocation bonuses, addressing if those are repaid or would be repaid short of the full term of an agreement. If it terminates early, also is good. Sometimes there'll be a pro rata repayment based on the number of months or years that had been completed before the agreement terminated. Including the benefits and expenses is important, both to have it avoid ambiguity and dispute later, and also to show and clearly have the picture of the full compensation package that the physician is getting is important. These are some of the items that often will be included in physician compensation agreements. With tail coverage and malpractice, the tail coverage component specifically, often it'll detail, if it's on the organization or the physician, sometimes it'll be only after a set period of time so that the tail would be earned, or after a year the organization pays a certain percentage, after 2 years a larger percentage, and kind of a vesting schedule of how the tail amount would be split. If the physician is either required to pay for their tail in whole or in part, often on the organization still wants to make sure that that tail is in place, and so will require that the physician provide a copy of the tail policy. And you'll often see that the organization requires the right to offset and get the tail insurance if the physician fails to, and then offset that money from any monies owed to the physician, and or seek a reimbursement from the physician. You obviously need to know the term and termination provisions. You can, most often with physician agreements, there will be a set term. There could be at-will employment. Some states are at-will employment states. I would say more often than not, physician arrangements are not at will. So that means that there's a set term. Usually automatic renewal is something I suggest if you think it's going to be a long-term relationship, because if there's a set term without automatic renewal, it just leaves open the potential that the parties forget to address and sign a new contract. And if so, you could find yourself inadvertently, when you need to have a contract, without one because it expired and just kind of slipped everyone's mind. So automatic renewal would not allow that to occur. Termination without cause would be that either party can terminate for no reason at all. With cause is when you have a breach or other cause provisions that you'll want to describe in the agreement that would allow termination usually earlier, immediately, or shorter than the without cause time. Immediate termination provisions often include things like loss of license, exclusion from federal health care program, a disability, if you're going to use terms like disability, often including what that means for your relationship is also advisable. And again, however the agreement can terminate, you want to keep in mind how termination would affect other provisions like bonus, tail coverage, some of the other things we had touched on. One final thing on suggested terms is restrictive covenants. The reasonableness is the central thing to any restrictive covenant provision. State law varies greatly on how restrictive a restrictive covenant, a non-compete, can be. So you'll want to look to what your state has set forth on that item specifically. And I would suggest when you're considering restrictive covenants that you consider all the arrangements and relationships with the physician. Often the reasonableness of a non-compete will factor into things like if the physician is an owner versus just an employee. Also, if it's a part-time employee, independent contractors are also looked at often very differently than employees. So the arrangement as a total will go into that consideration. And the last thing to touch on is 501c3 entities. And again, this is a little bit separate. Again, fair market value is an issue here, but not quite the same as we've been talking earlier with Stark and anti-kickback. To qualify for tax-exempt status, no part of an organization's net earnings shall inure to the whole or in part to the benefit of private individuals. The way that this applies in the healthcare setting often is that it applies to those with the power to exercise control or influence over the organization. This could apply to physicians, especially when they have actual substantial control over the organization's decisions. That's usually people like key medical directors, department chairs, voting board members, and if so, payments to that individual cannot be in excess of fair market value. There's a rebuttable presumption that requires special board approval procedures and documentation and consideration of comparable data if payments are outside fair market value. So just be aware, if you're talking about a key decision maker, you're going to need to look to the special process for that. The IRS has a healthcare provider reference guide that is helpful for some of these factors. And the IRS definition of fair market value is a bit different than earlier. It still talks about when it doesn't really tie as much to generating business between the parties, but more so reasonable compensation between willing and able buyers and sellers in an arm's length open transaction. So the penalties, if you're a 501c3 entity and found to be engaged in a prohibited payment situation, include loss of your exempt status, which would be huge for a 501c3 entity, repayment of the excess benefit, so the repayment of the amount that's above fair market value, and also an excise tax if you exceed fair market value payments. Those are the intermediate sanctions, which are less than losing your exempt status, but can be significant. The excise tax also increases substantially if the repayment and initial excise tax is not paid in a set period of time. So again, if you are aware of payments that have been made outside of fair market value, you'll want to take actions to determine that amount and repay it as soon as you can to avoid the penalty increasing. See, our time is about up, so I'll just give you the last final items here. Did want to let you know again, our healthcare blog has publications and previous webinars. Feel free to take a look at those for other resources that relate to these topics, and email me with any questions. We have some upcoming webinars. The next one on recruiting physicians and other practitioners is going to probably extend on some of these concepts on compensation as you're bringing physicians into your organization. And we do have past webinars that more thoroughly dive into the Stark anti-kickback and civil monetary penalties law. So if those are items that are coming into consideration with your relationships, I encourage you to look back at those webinars as well that give more examples and talk about some of the exceptions in further detail. Thank you very much for joining me. Again, feel free to send me an email, give me a call if you have questions, and look forward to hopefully having somebody join us in our future webinars. Thanks and have a great afternoon.